statement that I have on here that's spicy and funny. Enormous resources in the past accompanied while you're a small woman-owned business who are attempting to make something functional out of their garbage. Key statement: if you're mad, it's unfortunate that White Claw dislikes recycling and is going after a small woman-owned business who are attempting to make something functional out of their garbage. Like it's like this the product slide today. This one because making everybody had to sue everyone on anything. But you clearly did not sue White Claw. So you'd be like, what I'm going to do is sue White Claw for the burn from the candle wax. Or you knock over the candle and your house burns down. It's like it's White Claw's fault because this candle was, candles weren't made to be burned inside of an aluminum can. I want to know what you think. Chat. What do we think of the Yeezy foam runners? What do we think of the Yeezy foam runners? Like, what are they? Like, what are they? What are these shoes? What are these shoes? I love the fashion law too. I think the fashion law is fantastic. These shoes, what are these shoes? Okay, all of you are like, yes, see? I'd rather wear Crocs. I'd rather wear Crocs too. Somebody said Crocs, but make it easy. Space Crocs. Chat, y'all killing me. Sci-fi grandma shoes. These shoes are really something else, right? They really are something else. I'm trying to make this larger. And I don't think I can. Why can't I zoom? It won't let me zoom at all. I cannot zoom. All right, sorry, y'all. I tried to zoom. I cannot. I don't know why I can't zoom on this website, but I cannot. So there we go. These are the Yeezy foam runners. These are the Walmart imitation. Why Walmart wants to imitate these, I do not know. But Walmart has decided what we're going to do is sell these. I mean, y'all, do you think they look the same? Let me know. Do they look the same? Do they look the same to you? I want to know. Would you think that these were the same shoe if you saw them next to each other without the little things down below? I want to know. Let's talk about what they're arguing. Again, this is coming from thefashionlaw.com. Kanye West has escalated an already impending trademark battle, right? Because he's saying Walmart is already using his label. So he's already mad at Walmart. But yeah, he's already mad at Walmart. Ashley is like, yes, but what are they? Right. The Yeezys. So there's a trademark battle going on with Walmart already over the logo because the logos they say are the same. And now they're alleging that they are selling copycat versions of Yeezy foam runner shoes, according to a complaint filed in the California State Court Thursday. I will pull it up if we need to. Yeah, I think they look pretty similar too. I really do. Essentially, what West and Yeezy LLC are arguing is that because these are being sold in Walmart, it is cutting into their market share. Like these are so similar that people are like, oh, fuck it. I can just go to Walmart and pick these up. I don't need to pay for the Yeezys. because they're essentially the same shoe. The fact that Walmart offered footwear is trading on the design of the Yeezy shoes is further indicating that, as the plaintiffs argue, by comments on the Walmart website make clear that the consumers purchased the imitation shoe only because of its association with West and the Yeezy brand, right? Because nobody's just going, those look like great shoes. People who want to buy them want to wear Yeezys. Nobody's going, these are the shoes that we need. These look like they need to be in like a dystopian future drama. Like it's, I don't know, Mad Max, but space. Space Mad Max. Space Mad Max. These shoes, what is happening? Um, I don't think Yeezy and Walmart have the same demographic. It's a great point, Katya. I don't think they do at all. They are definitely a gag gift, as somebody just said in the chat. Looks like dinosaur. They are. They're from like Spaceballs. Make it dystopian. Anyway, they are arguing that the Walmart people would like to purchase the Yeezy foam runner, but they would have purchased it if it weren't for the cheaper knockoff imitation shoe. I don't know about that. I don't know if people who really want Yeezys are just going to Walmart. I wonder if the argument's going to be, hey, the people who are buying them at Walmart were never going to buy the Yeezys because they can't afford them and won't afford them. I don't want to say can't afford them, are choosing not to pay that much. I don't know how much these are selling for, but are choosing not to pay that much, but think it's funny so that they're going to buy the Walmart version. So I don't know if this is, they're going to argue it's cutting into market share. We'll see. I don't know. I don't know if it's the same demographic. So West and Yeezy point to comments on social media, which they assert. We're going to have to pull this and pull the comments from social media they included in the complaint, but we'll do that later. Not tonight. We have too much to go over. Yeah, okay. See, Haley, no. Right? No. No. To 200. No. Yeah, no. No. So the article goes on to say, meanwhile, West and Yeezy point to comments on social media, which they assert show that consumers are confused about the nature and source of the imitation shoes. Again, these are knockoffs. So there's going to be confusion. And if they can show that, then they might have a case for trademark infringement. And are associating the lookalike shoes with West and Yeezy, even though they have not authorized the manufacture and sale of the shoes and are not affiliated with the knockoffs. Knockoff in high fashion is such a huge problem that I can understand why they're going to have to go after this. So Kanye, let the broke people have things. I mean, it's a very fair comment. And law and subscribe this, yes, the true crime heiress to fashion. Chat, okay, I'm gonna finish the story because y'all are cracking me up in the chat and I appreciate you, and I'm gonna come back to it, but I want to finish getting through this story real quick because we have a lot to cover. So with the foregoing in mind, and given the economic harm that Walmart is allegedly causing West and Yeezy to experience as a result of diminished sales of the Yeezy foam runner, as well as harm to their reputation and property in the form of the Yeezy brand, Yeezy and West set out a claim under the unfair competition from the California Business and Professions Code. They also went after unnamed defendants in the law. Unnamed defendants ran afoul of the law by selling an imitation version of the popular and distinctive Yeezy foam runner. Well, it's definitely distinctive, isn't it? Notwithstanding comments by consumers where they should have been sufficient to alert Walmart to the presence of imitation goods on their website. Moreover, Walmart traded off the popularity and goodwill of West and Yeezy brand in marketing, selling, and profiting for the sale of imitation shoes. Can you imagine? There's probably someone out there getting the boxes because people sell like luxury boxes on Macari and on Poshmark and others. You can buy boxes. Can you imagine somebody like buying the box and just going to Walmart and throwing it in it and being like, look, I got you a pair of Yeezys. Because you would never know the difference. I can see it happening. I know it happens with knockoff bags more frequently than not. Anyway, selling and profiting from the sale of imitation shoes, thereby amounting to behavior that is immoral, unethical, oppressive, and or unscrupulous in that it was designed to confuse consumers and profit off the Yeezy brand. Well, we've already talked about immoral and unethical and how the law sometimes views these things. But yeah, it might be oppressive and unscrupulous in that it is anti-competitive and that it is knockoff goods. I am going to put this one on the docket to dive into later, see how Walmart responds, see what their next motion is. And when Walmart files a motion, come back round to following this because the fashion law does a great job of breaking down this complaint. The fact that this is a trademark infringement complaint, essentially revolving around knockoff goods. And damn if these shoes, these photos are at different angles, but damn if those shoes don't look similar. I mean, they look weird, both pairs, but it's, you've got the three lines here and the three lines here. You've got the same shape cutouts. It's just there's look. It'll be interesting to see what the trademarks are on this shoe and if they've trademarked the look and feel of this shoe. So that'll be very interesting to see. All right. What else do we have? There were others. Oh, Ringo. Ringo's next. Ringo's next. Ringo, our old friend. If you haven't seen the Ringo video, it's because YouTube has suppressed the ever loving shit out of it. I hear people coming into my office. I do. We're in the middle of the weekly roundup, child. Hi.
I thought you're live already.
I am live already. We're doing the weekly roundup. We're just about to talk about Ringo, which is not appropriate for you at all.
Yeah, make sure to subscribe and go on shot.com.
Okay, yes, you can come in and plug. You just wanted to come in and give a plug?
And am I popular?
Are you popular?
Yeah.
You're very popular with me.
Yay!
I love you.
Are you popular?
I don't know if we're that popular. We've got over 3,000 law nerds in here. We're having fun.
Yay!
We just like bringing the information to the people. You and Dolphiny go help Deb put away groceries.
We already did.
You already did. Well done.
The fridge food.
The fridge food. High five.
Now you gotta work on the cabinet after.
I'll do the cabinet after. You know I like to have it organized.
Popular! Bye.
Bye. Do you see Fred? He barely lifted his head. Bye, Griff. Don't forget to shut the door, please. Hold on. Hopefully, they will actually shut the door. We'll see. We'll see if that happens. We were just about to talk about Ringo. Like, that door needs to be shut. Oh, thank you guys for saying hi to G. He is feeling better. He's still got a sling on his shoulder. He's healing though. He's pretty funny. Thank you guys. He's sweet. He is. Yep, it is. Does your kid know the song from Wicked? No, but he will. The Bakers all have better hair than me. That kid's got great hair. He really does. He did totally leave me hanging with that high five. It happens. Let's get into Ringo. Now, if you haven't seen, here, I'll just swipe it because I don't think we did that yet. If you haven't seen my video of the Ringo case, it's probably because YouTube has suppressed it because it's 18 plus, because it makes all of the jokes. This is a salty case that I quite enjoyed because, it had to do with Ringo Starr and sex toys. You can imagine what the Ringo is, but they settled. They settled. But helpfully, BBC News attached the settlement. So you can just go link it. I'll link the BBC News article. And they linked the settlement. Hi, husband. My dad called you to tell me that I'm out of focus. I mean, I feel like I'm in focus, but tell him thank you. He could put it in the chat. He was very, well, I feel like I'm in focus. Tell him to Dad, refresh on the Facebook. I think I'm in focus. There may be. Look, man, I need to be out of focus. I am sick and sweaty, and I keep moving how close I am to the camera. Okay. Thanks, Dad. Well, he knows now. Thanks, B. This This is what live streaming is all about. All right, let's get back into the salty case. Are we in focus? Dad, refresh your stream. Some of you are like, you are in focus. Some of you are like, you're out of focus. It just is. We're trying to be crispy. I keep moving how close I am to the camera though, and it's a fixed focus lens. So thanks, Dad. All right, let's get back into the Ringo. Let's get into Ringo and sex toys. Yeah, I'll link it down below if you want to go watch. If you want to go watch that. Hold on, I can pull up a better version of this. This version has all of the shiz from the trademark court, and I downloaded it. Where did I put it? I put it in my notes. This is what happens when we're sick. Let's pull up the clean version of the Ringo settlement because it'll just be easier for everyone to see. All right. Ringo from Salty et al. This was a joint stipulation to dismiss opposition with regard to the trademark filing of the Ringo. Again, you can go watch that video. Because it's the Ringo. It's an O. They sell it on adamandeve.com. Oh my. Applicant Pacific Holdings was holding the trademark. We don't need to know what that is, but they given the coexistence agreement, which means they are going to coexist in the space, and Ringo Starr is not going to object to Ringo the. Now I've moved my camera, y'all. Tonight, they're not going to. They're going to be able to trademark in the category of sex toys, but not anything in the category with regard to Mr. Starkey Ringo Starr. And they put the coexistence agreement into here. So they've agreed that Momentum can use Ringo as long as it's not linking them to Adam and Eve, to Ringo Starr, the drummer, and not the toy. And so that the mark must be distinctive. And the agreement. Momentum acknowledges Starkey's ownership of Ringo and Ringo Starr marks and stage names, and agrees not to contest, aid in contesting, or take on any action that will adversely affect the validity, registration, or use of Starkey's marks for Ringo and Ringo Starr. So they can have it use Ringo with the space in their category, because trademarks are done in different categories. So people can have the same trademark thing, but in different categories. And that's where a lot of these fights come up. IP law is a very busy and actual area of law. So Ringo is going to be allowed with the space in the category. They are going to peacefully coexist. They've all agreed. Queen Levine signed off on it. So we know that they've all agreed. And the Ringo case, the Ringo trademark kerfuffle is settled, but it did bring us a big old giggle. If you're interested in currently the only episodes of Law Nerds After Dark, you can go watch Law Nerds After Dark. And I'm just unhappy with my camera this evening because I keep messing with it. So you can go watch Law Nerds After Dark, and yeah, and that'll cover the Ringo case. I can't even mention it without giggling, because Law Nerds After Dark. If you're in the chat and you've seen the Ringo case, will you just put, there's an O emoji, isn't there? Will you just put the O emoji in the case if you've seen the Ringo video? To share with the group what they are missing in that Ringo case, because you're missing all the money shots in the Ringo case. Oh, I can't help myself. All the money shots, all the Ringo. Oh, you guys are the best. A lot of you have seen Law Nerds After Dark. Yep, I see all of your O faces in the chat. Thank you for sharing your O faces. Those of you who have not seen Law Nerds After Dark, you need to do somebody asked if my dad has watched Law and Nerds After Dark. I'm gonna guess no. I'm gonna guess no. Oh, as a sexologist, it's my favorite case. See, I learned a lot covering that case. There were things I did not know. There were things I didn't know, and that's the end of the weekly roundup. We have rounded up. We have rounded up. We have rounded up. All right, Ringo fans, I love you guys. Chat's the best. There will be another Law Nerds After Dark. We'll just have to find the right case and just go head in, go elbow deep into another case for Law Nerds After Dark. Because it's fun. we'll just we'll just mark it 18 plus, demonetize it right off the bat, and just have a little fun with it. Because some of these cases are fucking funny. They just are. They're just funny. What's not funny is what's going on with Britney Spears. So we'll talk about Ringo shenanigans in Q&A. We're going to talk about Britney Spears. I covered this a lot in a special episode yesterday. I'm going to be releasing that on the podcast too if you just want to listen to the audio version. But there's a new fucking filing in the Britney case. Oh, and she's in Hawaii on vacation. And I was very happy to see Sam Asghari, her boyfriend, posting them kind of messing around on the plane with filters on Instagram and going on vacation. I'm very happy that Britney is in Hawaii. I know a lot were worried that her family would punish her after speaking up in court and like not allow her to do things. I'm glad that whatever she had planned, she is allowed to travel and go do that. She seemed, to be smiling with her boyfriend and belly laughing over some of the filters on Instagram. So let's get into this new filing. A lot, a lot of you asked me about it. And so, of course, we're going to talk about it. There are two new things that came up in the court records. First of all, was a minute order, and I'm going to bring it up because it covers shit that I've already said multiple times. And I'm like, but what I said was. So we're going to cover it. I'm going to close a few tabs so my computer doesn't absolutely have a fit on me from the stuff we've already covered. Let's get into this minute order from the court that was filed after the court hearing from June 23rd, 2021 at 1:30. This was prepared by the court. The following parties were present for the proceeding. Because I got onto the court call and then was not on the court call and then got back onto the court call, I missed everybody's appearances for the records. So these are the appearances for the records. When I say there are fucking flying fleets of lawyers, there are flying fleets of lawyers. Gerald Cohen, Jody Montgomery. So Jody Montgomery is the conservator of the person. Britney Spears, James Spears, Lynn Spears, Lorianne Wright, Sam Ingham, Britney's court-appointed attorney, Geraldine Weil. I believe Lorianne and Geraldine are both attorneys for Lynn Spears, Jonathan Park, Vivian Thuran, who we know is attorney for James Spears, Yasha, I can't pronounce your last name and I don't want to butcher it. Bronston? I'm going to butcher it anyway. No shade meant. Lynn Swanson, I believe, is also one of Lynn Spears' attorneys. Ronald Pearson, Gladstone Jones III, and David Nelson. I would have to go back through my chart of who all these attorneys belong to, but these are all of the attorneys. At least two of them belong to Lynn Spears. The rest of them go to both Jody Montgomery and James Spears and Britney, because Britney has counsel in Sam Ingham and then in Loeb and Loeb as well. So the matter is called for hearing. All parties appear via LA Court Connect. That means parties were not in court. They were on LA Court Connect. Different than the audio cast, this was the visual Court Connect where they were essentially in the court's Zoom. The court makes a brief statement prohibiting any photography, recording, and or broadcasting of the proceedings, whether remote or in person. So there's that. The court takes testimony. The court breaks for a short recess. Upon returning, the court finds that the remote audio attendance program is being recorded and instructs the court to terminate the RAAP. The court counsel and all parties confer, and this is what I was this is where we were with the court conferring before the audio cut at the end there. The court counsel and parties confer on the record regarding future filings, petitions, and or motions. The court directs the parties to contact the clerk for future hearing dates agreeable to the court. The court places the status hearing off calendar. Again, This was always a status hearing. This was for Brittany to be heard. There wasn't anything on the record to be decided, any action to be taken. It was literally just Brittany saying, this is the status of where I'm at. Sam Ingham had asked for that on the last court date. The other motions and hearings from the last court date got put over until July 14th. That includes things like the final split with Bessemer Trust, making Jody Montgomery the permanent conservator of the person, and if any new filings are made, then dealing with any new filings. And then there's a new filing with regard to appointment of the conservator. And this was shared today by Brittany Law Army on Twitter. That's the first place I saw it. A lot of you sent me that tweet. I follow Brittany Law Army on Twitter. They did live tweeting of the hearing and have done lots of breakdowns. They are very heavily covering this case and break down every single breaking thing in this case. So they are more up to the minute than I am for sure over there on the tweet on the street. So this is a filing. Let's get back to the bottom so we can see who filed it. This is being filed by Freeman, and Smiley, attorneys for James Spears, and by attorneys for James Spears, Holland and Knight. And did Bessemer's attorneys sign it? The attorneys for Lynn Spears at Loeb and Loeb signed it. And who else signed it? The other attorney for Lynn Spears signed it. The attorney for Britney Spears, the Loeb and Loeb counsel signed it. So the attorneys have all signed off. Let's get into what this document is and says, because I know a lot of people were like, wait a second. WTF is happening here? And for all of you, I see the super chats populating at the top. I will get to them. I'll take a break at the end of Brittany before we get into all of the Erica Girardi stuff and catch up on the super chats for sure. No, Brittany does not. Lynn Spears' attorneys. Lynn pays for their attorneys as an interested party. And as I just contradict myself, I overruled myself. No, we don't know how the court found out, but it was being like live streamed on the internet. It was being live streamed on Instagram. I don't know if the court administrators could tell that it was being recorded from the back end or if they were seeing it by monitoring social media, which is my guess that they were monitoring social media and that the law firms were also monitoring social media and somebody notified the bailiff or the court clerk that that was happening. That's my guess. But we don't know. The court didn't say. The court was like, oh, what we're not going to fucking do. Because the court had just gotten into I don't want to say tirade. The court had just kind of had a moment about leaked documents getting to the New York Times and how disappointed the court was that that happened and how it is the court's goal to protect the privacy of Britney Spears. And I know there's a lot that disagree with that, but protecting the medical privacy of Britney Spears is important to the court and should be, and was very upset that confidential sealed court records got leaked to the New York Times. Not happy about it. So this is to the judge regarding the hearing date on November 10th, 2020, when they were seeking to appoint the co-conservators of the estate and separate out the different responsibilities between Bessemer Trust and Jamie Spears. This has been pending for a while. This was just finalized and submitted by Sam Ingham, attorney for the petitioner, Sam Ingham. Conservatee. Conservatee is Britney Spears, is substantially unable to manage their own finances, has voluntarily requested appointment of a conservator, and good cause has been shown for appointment. Remember, despite everything, this is still a voluntary conservatorship. I know. And these are the checkbox of why this conservatorship is in place: is substantially unable to manage his or her financial resources or to resist fraud and undue influence. This is a petition only regarding the conservatorship of the estate, which is why the other boxes are not checked, though these are the boxes that would be checked on the other petitions. Is an adult, granting conservator powers exercised independently under Probate Code Section 2590. The conservatee need not attend the hearing. The successor conservator is not the spouse of the conservatee. That is adding Bessemer Trust. The conservatee not need attend. The bond is not required of Bessemer Trust. Bond is still required of James P. Spears, as ordered previously. A bond is money that has to be put up. So if you mess up, the bond gets forfeited. It's a rough comparison to a construction bond. Like that's a really rough comparison, but I think it helps. Um, the successor conservator, nope. They lined it out. They're like, nope, that's not the one. The treatment shall be performed by an accredited petitioner relief. The co-conservator of the estate is granted authorization under probate code section 2590 to exercise independently the powers specified in attachment 24. We're going to get to those powers and we'll see the powers that Bessemer Trust is being granted. And that's what this is. The not the successor conservator, but the co-conservator of the estate are granted the powers below. Other orders specified in attachment 29 are granted. This order is effective on the date signed. This will probably be signed by the court in a few days. This has been, as I said, ongoing for months. Conservatorship of Brittany Jean Spears. Oh, it binged. I heard it. Did you all hear it? It binged. It binged. So even when we're talking about serious topics, we're gonna take a moment. Oh, it binged. Move your head. Thanks, Law Nerds. It's a good time to remind you to like and subscribe. And if you're here to talk about Britney stuff, we have a whole playlist of Britney stuff. And if you haven't subscribed yet, go ahead and like and subscribe. Yay, it binged, it binged, it binged. It binged, it binged. All right, let's get back into this. It binged, it binged. Yay for 135. All right, let's get into the powers. This is something y'all ask about a lot. Like, what are the powers of the conservators? And I will go see if I can find one of these. I have not seen one with regard to the personal conservatorship, but we'll go look. So these are the powers granted. This is in addition to the conservatorship of the person. This is with regard to conservatorship of the money shit, the estate only. Well played. This is a fantastic comment. Bingo. Appreciated. Let's get back into serious shit. All right. Conservatorship of Brittany Jean Spears. Independent powers. James P. Spears and Bessemer Trust, as co-conservators of the estate, are granted the following powers set forth in Probate Code 2590 et sec to be expressly exercised jointly by them. The power to operate at the risk of the estate, a business, farm, or enterprise constituting an asset of the estate. I only laugh because that's the language in the probate code and it's not modified. But I want Brittany to have a farm. Don't y'all think Brittany would be happy just getting to be on a farm? Like, I want Brittany to be able to operate a farm and just be like, fuck you fuckers. I'm going to go farm lavender and baby goats and it's going to be amazing. Like, I don't know if she necessarily wants that because she did say in court that she was upset that she wasn't able to have acupuncture and massage. But you can get a bougie farm. I think she could have a bougie farm. I would love that for her. Like, I want that for her. It's what came to mind, Diva Views. It's what came to mind. It's what came to mind. I want a farm for her. I don't know if she wants that for herself, but it just seems so idyllic. I know farm life is hard. I get it. Moving on. They can operate a business or enterprise constituting an asset of an estate. That means that they can still run all of her businesses. They can run the perfume line, the music. They can license her name and likeness. They can license her music to movies, all of that stuff. The power to pay, collect, compromise, or otherwise adjust claims, debts, or demands upon the conservatorship. So they can handle all the money shit. Additional orders. These are what I'm really more interested in. Ugh. Sorry, nose congested. James P. Spears and Bessemer Trust Company of California, as co-conservators of the estate, are granted the following additional powers. 1, the power to obtain all documents and records related to the conservatee. That means that Bessemer Trust is going to be able to get into every document that's been filed and can actually go back and look at everything that's been done with her business. And that is really a good thing because now we have another set of eyes that is supposed to be acting in Britney's best interest, getting grants to go back and look at this. What this also indicates to me is that this has not been done yet. This, until this is signed, Bessemer doesn't have access to this stuff. So even though the court has approved them, they haven't gotten to move into getting all the documents and stuff. But this is a really good thing. All contracts, information relating to credit cards, bank statements, estate planning documents, receivables, and any and all powers of attorney. The power to take all actions necessary to secure the assets, so to protect the assets. The power to revoke all powers of attorney, including powers of attorney for making healthcare decisions and managing real estate, and to terminate any and all agencies. This bumps up into where the conservatorship of the person also has power, but powers of attorney are secondary to a conservatorship. So you can't have a power of attorney out there too. There probably aren't any at this point because of how long this has been going on. The power to commence and maintain litigation, we've already seen them do that in the past and issue protective orders and such. To participate in litigation with respect to which the conservatee is a party or has an interest, the power to retain counsel and experts, which we're seeing happen a lot, and to pay the same from the conservatorship estate, not only as to the family law case, but for any other matter. So that's regarding to any attorneys needed, excuse me, any attorneys needed with regard to the child custody, which will continue going on until the kids are 18 years old, but also anything dealing with business contracts, signing business contracts, making business agreements. This is why there's statements that this feels like forced work. They make all those decisions. Britney doesn't have the right. Yes, I said does not legally have the right to sign off on it. Now, I think that the business managers shouldn't be dicks and they should be like, "Hey Brittany, do you want your song used in this commercial and or movie? It's your music. What do you want?" But they've said straight up in other court filings, Brittany does not have the right to know who we're hiring as the business manager. And I think when I was covering it on the live, my exact words were, "I'm sorry, what the fuck?" But I think they should work with her, but they are not obligated to work with her. They can make all those decisions, which is probably where a lot of her frustration is coming from. Because wouldn't you be frustrated too? It's just, it reminds me of when my 13-year-old's like, "Well, why do I have to wear pants to school?" And I'm like, "Because it's like 30 degrees outside and you're going to be really cold." And he's like, "Well, I don't want to wear pants." I'm like, "Fine, don't wear pants." And he comes home and he's like, "Why didn't you tell me to wear pants?" But he's 13. He's not 39 years old. You should get to choose what happens to your legacy, your music, your perfume, your name, your likeness, all of it. The power to perform any and all acts that the conservatee can perform, whether individual or in a representative capacity, with respect to the local, state, or federal tax liabilities. Yes, they have to do all of the financial shit. They have to pay all of the tax. They have to deal with all the tax stuff. Tax, tax, tax. The power to prosecute civil harassment restraining orders to be deemed appropriate. We've already seen them do this in the past with regard to, I'm sick and the name is not going to come to me. It will come to me later. The dude, you know who I'm talking about. Chat knows who I'm talking about. The guy that was like her businessy manager, Sam Lufty, before this. I don't know if there's been others, but there could be. Like if she was getting stalked from paparazzi, they could actually file civil harassment causes of action for her. The power and authorization to pursue this is why these are special, because this is not in the probate code. The power and authorization to pursue opportunities related to professional commitments, work, she can work, and activities including but not limited to performing, recording, videos, tours, TV shows, and other similar activities, as long as they are approved by the conservator of the person and the conservatee's medical team. Now, we know after Britney's court hearing how she feels about her medical team. She said that she fell to her knees and thanked God when her prior therapist, who put her on lithium, died. That is a very real and visceral response. The conservator of her person used to be her dad. So when her dad agreed with her dad, then he could sign these things. We heard her say in court that she feels that Jody Montgomery is becoming as bad as her dad. I am optimistic that at least having a different conservator of the person means there's more conversation about whether she can perform and that maybe what she wants will be taken into consideration. And she's made it clear, like, I am not performing. Like there's no more dance monkey dance happening up in here. Dance for me, dance for me, dance for me. Mm-hmm. Like we're done. There's no, you cannot make me work. You better work. I'm not working. Fuck off. And that's going to end up in breached contracts if they sign contracts for her that she's going to breach, which is end up costing the estate more. But I think at this point, Emily, opinion. I think at this point, there is no way to argue if they sign her into other obligations that she doesn't meet and gets her estate sued over it, that they can say, well, we in good faith thought that she would work. No, she has made it clear that what she's not going to do is work. So I hope that they do not sign her into any contracts. Yes, they can license her image, her likeness, her name to things, but I don't think they can force her to perform or record at this point. And if she breaks that contract, say in good faith, we thought she was going to do it. Because if she breaks the contract, guess what? Her estate gets sued. And then more money has to go out for her to deal with the breach of contract that they can set her up to literally fail. The power to select, invest in, and monitor the particular investment vehicles for the conservatorship estate. I wonder if Brittany's into crypto. Oh, never mind. She doesn't have a say in what she's into. If Brittany was like, put it all on GameStop, she doesn't get to make that choice. Oh, I shouldn't joke. It makes me so fucking mad and sad. But this is what was agreed to years ago. This is just adding Bessemer to what already exists. This is not new. It's really just granting Bessemer Trust the same powers that Jamie Spears had as an individual, and before that, Jamie and Andrew Wallet had as co-conservators of the estate. These are not new things. This is what it is. So the power over investments, the power to employ attorneys, accountants, agents, depositories, and employees, and to pay the expenses. So they can hire all the people and pay for it from the estate. The power to contract for the conservatorship and perform outside contracts and thereby bind the estate, including asserting and waiving confidentiality agreements. They can assert and waive confidentiality agreements. Let that sink in. They can get the information that they want to get. That could be used for nefarious purpose. I hope that it wouldn't be, but I have no optimism left about what this conservatorship may or may not do. I want to know what the purpose of, like, what came up where they needed to waive a confidentiality agreement? Like, was it a recording contract? What was it? Because this could be more specific. This is very broad. The conservators are ordered to file an accounting no later than March 1st, 2022. In order to show cause, hearing is set. The conservatives request to suspend James Spears immediately upon the appointment of Bessemer Trust as sole conservator of the estate is denied without prejudice. And we already saw this happen in court. The court indicated at that time at a previous hearing that the court would entertain the idea of removing James P. Spears as the conservator of the estate after Bessemer had time to onboard, so that there needed to be a transition because they thought without a transition period, it would harm the estate. I agree with the court in that you could end up, if there isn't a clean transition where Bessemer can get all the information from Jamie Spears, there could be damage to the estate. There could be hiding of assets. So this transition, I think, needs to have Bessemer come in and then phase James Spears out to protect the estate. I know everybody is like, get him the fuck out now. I get it. I think that legally, the transition is proper, and the court made very clear that she would entertain that motion at a future time. The conservatees request, this is Brittany's request, for an order directing James P. Spears, TriStar Sports and Entertainment, and Michael Caine to deliver the entire conservatorship estate together with all books and records forthwith to Bessemer Trust as sole conservator is denied without prejudice. They're trying to work this out. I don't like that this was denied. I think that Bessemer should have a look at what the fuck TriStar was up to too. And I hope that that happens. And I hope that Bessemer gets access to all the books. They have access to it up above. The court might have believed it was duplicative. I think the court could have granted it to make it clear. The court could have also modified this so it isn't forthwith and given them a date. But it's clear that the conservative is asking for Bessemer to have access to everything to look at what's been going on, and that is Bessemer's job. But it does grant them access to all documents and records relating to the conservatee and her assets. So under this, Bessemer can get to that. I would have liked to seen the court make a statement saying, yes, I'm not going to order it forthwith. I will order it by this date within 45 days of signing this agreement or whatever it is. I would have liked to have seen that. And if it's needed in the future, I'm sure the court will do it, because Sam Ingham's can't let it slide if Bessemer doesn't get access to what they're supposed to get access to. Cannot. Has to make sure Bessemer gets access to these documents. And this is just signed by all the various attorneys and then faxed in. It's a lot. It's a lot. Let's take a minute. I have to blow my nose. And then we're going to get into Erica Jane stuff. And we've been talking for an hour and 14 minutes. I'm going to remind you to do the likey things and the subscribey things and all the things. And I'm going to go through a couple quick questions, sweep the super chats, and then get into the Erica Jane stuff, because her lawyers are pissed. They are pissed. There is a YouTube video linked in this legal document. Where have we seen that before? There are tweets linked in this legal document. Where have we seen that before? This is Salts Brown 2.0 going on in this motion. And I'm look, I'm amused. I'm amused. So let me get into the super chats real quick. And I'm sorry. I hate blowing my nose on camera. I feel like I should just put up something for y'all to read so I can blow my nose. Maybe I'm just gonna we'll put up the conservatorship stuff real quick so you guys can look at it. Because I feel like I can't just blow my nose on camera. It's so embarrassing. I'll be right back. I'll be right back. How do Twitch streamers do it? They always have like a little video where it's like, I'll be right back. I'll be right back. So we'll just I don't think I've ever taken a break during stream. Sorry, y'all. And thank you, y'all. It happens. I feel like I can breathe. Breathing is good when you're trying to talk. Breathing is essential to trying to talk. Breathing is essential to trying to talk. Yeah, Brittany did say she wanted to sue her family. I think that having Bessemer get access to everything is critical. Is critical for sure. So I think that's critical. So yeah. All right. It is better than forgetting to mute your mic while peeing on a Zoom call, or peeing during a recorded interview, which I've had to listen through numerous police recorded interviews where I've had to listen to officers not take off there and stop their recording, because that is definitely happened. All right. I have absolutely been doing all the things Can Bessemer file a lawyer? Yes, Bessemer can. Well, it'd be hard because they have co-powers. Bessemer can raise a lot of questions though, and I'm interested to see if they do. I'm interested to see if they do. Somebody has to. So, if there's questions, I'm optimistic that Bessemer will uncover them. I'm very, very optimistic. So we'll see. We'll see. Optimistic. All right. Super chats that I missed. JC said there are so many dudes named Sam in the Britney thing. There are a lot of dudes named Sam. Yes. Um, Selena, hello. She could sell lavender scented goats. She could sell lavender scented goats. Did you just sneeze? Did you all hear that? I don't know if you picked that up. You sneezed. And yeah, okay. Okay, Fred, just do your thing back there. Alrighty. Um, Wendy B said, in 1 minute, I'm going strong on 2 minutes behind because my kids are strong on hyper tonight. I hear you, Wendy B. Fee simple absolute. Lawyer humor said, love the show, Emily. Do we know or have any inclination as to how the court found out? I pulled that up. I don't even think I said the name out loud when I pulled that up. So I'm glad I looked at this again. Just Me said, so is the Britney estate paying for all the lawyers? Most. I have another episode with regard to the lawyer fees because there's some fighting over the lawyer fees and there was some tea in those documents. They're in the Britney Spears playlist and I will try to link it and remember to link it to this video. But there's a lot of lawyer fees. Like there's a lot of lawyers fees. Um, there's a lot of lawyer fees. You're welcome. Um, Alejandro said, "What when Britney said she was forced to do the tour in 2019, she meant her Piece of Me tour, Europe. It was right after her Vegas residency ended. How can her conservators force her to work?" Well, from what she said in court, it sounded to me that they signed the contracts. I don't know if they ran them by her or not. They signed the contracts for the tour and said to her, you're going to lose a fuck ton of money if you don't do this. It's easier for you to just do it. And she said that in court that they were saying it's easier to just do it. It's easier to just do it. And she's like, but I need a break. That was the time when her dad had charge of both and was making these decisions for both. And she said in court, he worked me so hard. I'm hoping that having another conservator of the person means that there is a stopgap between signing these documents because the conservator of the person has to agree. And hopefully someone takes what Britney wants into fucking consideration because it seems like that hasn't been happening. So, hi, Fred. Yeah, he woke up. Alrighty. So I think that is how they forced her to work. They signed the contracts. And when she said, I don't want to do this, they said, breaking these contracts is going to be really expensive. It's better to just do it. And she was like, what am I supposed to do? Like, what am I supposed to do? Yes, I keep messing with my focus tonight because I can't tell if it's me now because now I'm paranoid. Thanks, Dad. Thanks, Dad. Teasing. Um, let's see what else I got. Amy Yost, hey girl, missed you all. We won a 2-week trial yesterday. Congratulations. For sickness, peel and boil ginger root for 5 minutes. I've been doing ginger. Discard the steeped chamomile tea for 5 minutes. Thank you for the suggestions. We did the things. Mariah said Ethan and Gila did buy those as a joke for Ian's birthday. For Ethan's birthday. For Ian's birthday. I'll have to go find it. Are we just? Is this? Are we? Okay. We have cat. J Jersey Girl said, looks like something you put on to take the trash out to the curb. Much love for the Yeezys. I know, right? Marvin Lott said, I'm on my lunch, so I can't stick around. Hello, but I just wanted to say that I appreciate you, Emily. Keep up the great work. Thank you so much. Heather, thank you for the super chat. Teresa Minnesota, good to see you. Has the home state of Lynn Wood taken moves to disbar him? Same with Sidney Powell. I have not seen that reported in the news. I have also not looked, but I will look and we will see what happens. I imagine that others have to, like shots across the bow. Jesse E said hello from Bozeman, Montana. MCU's She-Hulk TV show 2022 will be a legal comedy. Ooh, plan to watch? I mean, if it's a legal comedy, yes. Emily, it's not sponsored by Adam and Eve. Matt Bond said, I give a monkey crap, Edward's so dreamy. there's a big part of me that's Team Jacob. I'm gonna just be honest. We'll court of public opinion that another night. Put it on the list. Team Edward, Team Jacob is going into court of public opinion. And then I'm caught up, except for this one. Is it possible that Brittany will spend what remains of her fortune trying to get her life back? I very, very deeply hope not. Is it a possibility? Yes. But I very, very much hope that that does not happen. And I hope that after this and she's free, she can release a book. She can release things that she can profit off of. Her fan base is there to support her. If she chose to go on tour and said, hey, I'm doing a Vegas residency, it would sell out instantly. And she could say, I'm doing 3 nights a week. I'm doing 1 night a week. It would sell out. And hopefully not Ticketmaster, but Brittany would get most of that money. She can write her own ticket as to what she wants to do after this when she feels safe. It's clear to me that Brittany does not feel safe and doesn't feel safe to perform and doesn't feel safe just making money for the people that she feels keeping her trapped in her home and keeping her in this conservatorship. She's like, why would I make money so you can all turn around and use the money to do what I don't want you to do? I'm going to just stop making money. Fuck all of you. I can understand it. From what I've read and seen is that Erica's attorneys told her to give the $15 million to the victims after one of her co-stars handed over $5 million. Erica asked her to keep. She said no, and her lawyers got angry. I have not seen anything about that, but I will look into it. Y'all are just going to keep with the super chats. I'm going to have to move on to Erica or we're not going to get through it. It's so much stuff. Have you seen the movie I Care a Lot? No. A woman convinces the court to allow her to be a legal guardian over an elderly stranger to swindle money. I haven't seen that. I will watch it. The Yeezy shoes look like Jason X. Fair. Hello, Matt Bond. Good to see you. Monkey Ella is for all the bad guys. All right, let's go. Yes, Matt Bond, Urban Outfitters. Well, I don't know what their split is, but her estate is still making money off of that. Her estate is still making this money. So, Kempire, it's good to see you. We're getting into the tea, friend. We are getting into the Erica Girardi tea. And we're not going to stop until it's done. There's tea to be spelled. Mods, I'm sorry. Take a bathroom break. We have tea to spill. And we have Pondered Fred curled up on like literally my lap. So here, let me back up a little bit so his head's not smushed. He's literally on the arm of my chair. Hi. We're just the most codependent little kitty we've ever seen. I love a codependent cat. I do. I love a cuddly cat. Hi. We're going to talk about Erica Jane. Are you ready? This is some shit. She's a dog person. I know. Let's get it. All right. Speaking of mention it all, I drank way too much of the wine that was sent by our good friend, No Filter Zach. It was fantastic. It really is low sugar, but the alcohol percentage on it is higher than your average wine or White Claw, which was a surprise. And it was delicious. And I need, oh my God, you're falling. What are you doing? You can't fall. And I need to purchase more of it because I drank it all. Well, I shared some with my neighbor, but it was delicious. She liked it too. We enjoyed it. All right, you. Your brother's in here. Why don't you go play with your brother? You can be a palate cleanser later before we do court of public opinion. Pondered. Go on, brother's back there. Oh, hello, brother. All right. Now that everybody has come into my live tonight, we're just going to start time stamping the interruptions. George is in here too. Hi, George. George is like, I am dignified. I do not need to beg for attention. You will all come to me. Where Fred is like, no, fuck it. I want to be in your face. George is like, we'll see. All right. Let's get into Erica Jane. I will be back for questions after this for sure. Let's just... What is going on in the bankruptcy of Tom Girardi? A lot has happened since the last time we talked about it, and we have talked about what's going on with Erica Jane, and that's what we're talking about tonight. I've given my thoughts on the hustler and the housewife. We've talked about some of the things that have gone on in court, but there have been a lot of new filings. The new filings are mostly in there's lots in both. The filings we're talking about are in the Girardi Keese side of the bankruptcy. There are two. One over the law firm Girardi Keese and one for Tom Girardi as an individual. Erica is being pulled into both of them. Special counsel have been appointed in both. Special counsel on the Tom Girardi side as an individual is Boris Trezon. Did you all see Salty posting pictures, having drinks with him on the Twitter and the Instagram? It's like 1 degree of salt separation to literally everything in LA at the moment. But he was having drinks with Boris Trezon. I'm like, oh, of course. Of course you all have a case together. But he is the special litigator on the other side, on the Tom Girardi as an individual human side. We're talking about the Girardi Keese side. The court appointed Ron Richards, who a lot of you are familiar with from Twitter. He has done interviews up on the YouTubes with Sherelle's World and Up and Adam, and I think No Filter Zach and others. That's going to come up tonight. That's going to come up. Erica's attorneys are pissed. Then we saw the motion of Erica's attorneys saying we need to be removed as counsel. Then we saw the just kidding. We're all good. We've fixed the relationship. I've covered that in other content. What I haven't gotten into is the fact that there is now an opposition of the Girardi Keese trustee. So the trustee for the law firm is opposing the stipulated relief and settlement of the Ruigomez family on the Tom Girardi side. That's a big deal. We're going to get into that another day because it's so much going on with Erica, and I don't want to give this a short coverage, but this is going on where you now have the two trustees on the different sides saying, hey, wait a second. So, opposition to motion to approve stipulation between Jason Rund, the creditor on the Tom Girardi as a human side, and secured creditors Joseph Ruigomez, Jamie Ruigomez, Kathleen Ruigomez for relief from the stay. We're going to get into that. There is a declaration of Ron Richards in this one as well. But if we get into this, we're not going to have time to get into the other stuff, and there is so much other stuff that's going on too. So now there is disagreement between the two bankruptcy trustees with regard to that stay, and I will do a breakdown of, I think what will be most helpful is to do a breakdown of the stipulated agreement with the Rigomez family. I think there's a lot of interest in seeing how they're made whole, especially after them sharing their story in the Housewife and the Hustler it's not really a documentary because it's not being filmed contemporaneously. Piece, investigative journalism piece. I think that's what it is. So after that being shared, I think a lot of us are very interested to see that they are made whole. And with that, I'm very interested to see what the stipulated agreement is and then what these objections are. And we're going to get to that, just not tonight. So what else is going on? There have been multiple motions filed by Ron Richards as special litigation counsel for the bankruptcy estate in the Girardi Keese law firm side of the bankruptcy. The first one was with regard to getting information from Erica's landlord. We talked about that Tuesday, last Friday. Like, what day is it today? We talked about that previously. He wanted essentially source of funds. Like, yeah, boo, how are you paying for all of that though? Because the allegations, and they're repeated here, the allegations are that there is evidence in tax documents that Erica has received. I'm trying to find exactly where it says it, that Erica's companies have received $20 million spanning multiple years in her companies from the law firm. This was first discussed first alluded to in the lawsuit from Edelson PC against Tom Girardi in Illinois. That's kind of the tip of the iceberg of this whole fucking mess. So a lot of these facts are, okay, well, it looks like Erica's companies may have received over $20 million of assets from Girardi Keese. What we're going to need is that money back. And if these were fraudulently transferred, we're going to need to know how people are getting paid, because if it's being paid out of funds that should be going back to Girardi Keese, we need that money back inside the bankruptcy so the bankruptcy trustee can distribute it out to the debtors, not the debtors, the creditors. We're going to misspeak. I'm sick. It happens. So that money can be redistributed to the creditors. There is allegations in all of these documents. Most of them lay out the same exact facts with regard to different parties. that Erica created a new company after news broke of the scandal, which appears to simply be a successor company. So saying is it raises the question of whether she is trying to protect assets. It is a good question. But that doesn't indicate she knew before. It indicates that she became aware and was like, oh, fuck, what are we doing? But that's not going to work if the assets can be traced back to money lent to her from the law firm. Erica has multiple financial accounts, and the debtor's books show Erica owes large receivables to the debtor. Erica has refused to provide access to her management company, CPA, who also houses her management company, or any books or records of EJ Global or any of her affiliated companies. They are saying in this, as each day goes by, Erica has been publicly dissipating community assets by selling her clothes on public websites. Well, that got stopped. Has she gotten back to it? I don't know if she's gotten back. She talked about it in the show last week that stuff was getting sold on whatever the French website was. But I think the court in Edelson stopped it, and I don't think it has happened again since the bankruptcy, but I could be wrong on that. Flaunting large jewels on social media, true story, and on television, and has done nothing to assist in the return of structured firm payments being made to her inside of the firm by the California Lottery? What? Oh, I read that wrong. And has done nothing to assist with the return of structured firm payments being made to her instead of the firm by the California Lottery. This is a payout from a lawsuit. She's getting the firm portion, the payments that should be going to the law firm were signed over to her. So she's receiving payments that should be going to the law firm. Those payments have to be disengorged from her and go into the law firm so the law firm can pay the clients that it didn't fucking pay. Notwithstanding, she was contacted through counsel over 12 days ago. Well, I mean, that is fast. So this motion and the facts regarding it are asking, sorry for, pardon my scroll, are trying to get to the accountant of Erica Jane. Now, Ron Richards has also filed a motion to get information from the family law attorney of Erica Jane. I imagine we'll see objections with regard to attorney-client privilege. They are wanting source of funds, like, how you getting paid? Where'd that money come from? And does that money belong in the bankruptcy? What is the source of funds on that? So, as there is this flurry of activity from Ron Richards since he was appointed earlier this month, he has filed at least 4 motions as special litigation counsel to try to get to this information, try to get the documents, and try to figure out where Erica's money is. Most of these source of fund motions are like, hey, show us what bank account you were paid from. So at least we have the bank account numbers to go after. She's not cooperating. Well, Erica's lawyers aren't having it. Erica's lawyers, in what I have called Erica Strikes Back, have said that Erica is in fact cooperating. They are not pleased with what Ron Richards is up to, and they have made a motion for reconsideration. Look, special litigation counsel says she's not cooperating at all and that the other parties are going to have to disclose this. The other parties in all of these motions filed by Richards, the other parties say, we will cooperate with a court order, but you need a valid court order. Well, they have to. It protects their ass. They can't just give out privileged information without the court ordering them to give out such information. They have an obligation and a duty to protect their client no matter what they or anyone else thinks of their client. That is an absolute duty. A duty Tom Girardi also owed to his client, and that is not lost on me. So Erica's attorneys have filed a motion for reconsideration of the order appointing Ron Richards as special counsel. They are not pleased. They have lots to say. We're going to get into it. The reason I'm covering it is 1, it includes YouTube video links. 2, it talks about Twitter. And 3, I previously said that the things said on Twitter before Richards was appointed, though people don't like them, though some of the tweets were shady, they weren't he wasn't a litigant. He wasn't an attorney as a part of this case, but he is now an attorney part of this case, and they are bringing up things that have happened since he became an attorney part of this case. And there's just some really interesting stuff here. So I need some more water. We're going to talk about Twitter. We're going to talk about what attorneys they're saying can and can't do. Y'all can make your own decisions. We're just covering the court documents. It's interesting stuff. It's interesting stuff. Sitting here hoping I remember to swoosh into it so it's easier for everybody to timestamp, but we're just hoping we are. Um, let's get into this. This motion is brought pursuant to rules of the Federal Rule of Civil Procedure, made applicable to this proceeding by the Federal Rules of Bankruptcy Procedure. Legal, 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 legal stuff. On the ground that based on new evidence of events occurring after the hearing on an entry of employment order, the court should reconsider its decision to grant the Chapter 7 trustee's application to employ Mr. Richards as special litigation counsel. Look, this is Erica's attorney's side of this. I'm sure that the bankruptcy trustee will file just like they did last time. I'm sure they will file again. When I said earlier, if the court denied the motion, it's because the court didn't want to deal with this. This is the this I was referring to. I said the court might say, this is messy. This is already messy, and I don't want to have extra messy. I want this to not be messier, and this is making it messier. But the court also said in that order that they were not going to limit the First Amendment rights of one of the attorneys involved. But what we have seen is the obligations of attorneys involved in a particular case are different than your average attorney not involved in the case having First Amendment rights to free speech. They are different because the rules of professional conduct apply differently. And let's just get into it. Let's keep going. They're asking to vacate the employment order, and they say specifically Mr. Richards' extrajudicial statements, including on social media, violate the I'm going to call the California Rules of Professional Conduct the RPC. That is the Rules of Professional Conduct. I can't just say all the things all the time. The California Business and Professions Code, that one's going to be B&P. Prejudice Girardi's rights through wholly improper, conclusory, and unfounded public vilification, damage to the legitimacy of these proceedings, and appear in intentionally designed to destroy Girardi's right to defend herself and assert her rights in this proceeding and otherwise. This is the thing. Erica has a right to trial inside of the bankruptcy if she fights some of these things. So you cannot make damaging extrajudicial statements. There are limits to them. And earlier on, before he was appointed, what I had said is, and I broke down some of the statements in an other episode of the Emily Show, that these things were opinion, these things were reporting of facts. You guys will see what they are arguing here, but once you're appointed, I assumed, and don't follow Richards closely on Twitter, but I assumed that the tweets would stick to just kind of factual statements of this happened, that happened, this is filed, that's filed, go see it for yourself. They're saying that it's gone beyond that. They demonstrate that Richards has violated Rule 2014 of the Federal Rules of Bankruptcy Court. This motion is based on notice of motion and the attached stuff, the attached legal stuff. There's going to be an opposition to this. We'll cover it when there is. La, 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 la. La, 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 la. We're not going to try this on the merits. We'll talk about the merits more at the when we get the opposition. We're going to say what they said is happening and why they say it's improper. And then we're going to move on to questions because it's already a long night. This motion is not brought lightly. I like the heavy tone with which we're starting out. We've now gone through one water, one tea, and we've moved on to the backup water. We're going to keep it moving. La la la. This motion is not brought lightly. Yes, we're getting into dramatic voice. It's lawyers shading each other. It's fantastic. We love some lawyer shade up in here. When like legal meets housewives tea, here for it. Also, glad that my name's not being brought up into it like other cases I've covered. Glad to just get to watch lawyers be angry with each other from the sidelines. It is based on alarming new evidence and events, and it will not, nor is it intended to, interfere in any way with the investigation of the Chapter 7 trustee. To be clear, movement and part. Sorry, I'm trying to make this big enough for y'all to see and to have it not move on the page. There we go. To be clear, movement and party and interest Erica Girardi, Miss Girardi, or EJ. We can call her EJ. There's always an EJ, isn't there? Well, she's EJ now. Sorry, Erica Jane, you're EJ. Has been and remains willing to cooperate fully with the trustees' investigation in this bankruptcy. EJ has already cooperated in the related case. It's like, look, she's being perfectly cooperative with the other special litigator. What's your problem? Miss Girardi, damn it, EJ, however, is not a media fiction. She is a real person with rights. Accurate. She has rights. All defendants have rights. No matter how much you may think they suck, they all have the same legal rights. People that you love and people that you hate all have the same legal rights. And they should be applied equally and fairly. Everyone should be treated the same under the law. Don't make me go pull Lady Justice and her blindfold back out here. The law is supposed to be blind, so it is supposed to apply equally. We will have a debate about the truth of that statement another time, but that is how it's supposed to work. So yes, true statement. She is a person with rights, including the right to be treated fairly in these proceedings based on actual evidence and law, like facts. True. It is morally wrong, legally wrong, and unethical under the RPC for Girardi, EJ, to be tried extrajudicially by an officer of this court. That is true. You are going to have to look at the statements we pull up and see what you think. But yes, she cannot be tried extrajudicially by an officer of this court. And this is the second case where we've seen lawyers' statements on Twitter come into court filings. I think these are more on the line than things Salt said. The stuff Salt said, I thought was looking for evidence, asking for evidence, and asking for witnesses. These statements are different than that. Absolutely. But whether they violate the RPC is going to be for the court. And whether you think Girardi's being tried extrajudicially, I am curious to see. Even if you think she sucks, the lawyers can't engage in that. Other people on social media can. This is a lawyer in the case. By way of vicious, conclusory, and speculative public vilification, all without evidence, which even if it existed, should and must be presented and adjudicated by the court. Right, because that's where it goes, not the court of public opinion. Everyone else gets to try it, the court of public opinion, but not the actual lawyers. The new evidence, that's why we have a segment called Court of Public Opinion. The new evidence that has given rise to this motion goes to the integrity of the proceedings before this court. Those are strong lawyer language. I know that like vicious and conclusory feels strong. This goes to the integrity of the proceedings is strong language coming out to point to the judge that this calls everything into process or everything into question. And there should be integrity in the proceedings. Getting into integrity in the practice of law while talking about John Girardi. The irony is not lost. Only this court has the power and duty to ensure and enforce the integrity of these proceedings. Your Honor, it's up to you to protect the integrity of the proceedings. Indeed, the fact that GK and TG, the law firm and the person, cases involve the most serious allegations against attorneys, including violations of trust and allegations of embezzlement of client funds, makes it all the more important that this court control and ensure the legitimacy of these proceedings. This includes review by the court of real-world extrajudicial. God, I hate saying extrajudicial, and I'm going to have to say it a lot. Do not take a drink every time I say extrajudicial. It's going to come up a lot. It's going to start we're going to call that EJ2 in a second. We're going to call it all EJ. Saying extrajudicial is hard. Statements of officers of the court, attorneys, and whose benefit the court has exercised discretion. They talk about the duties. They talk about the application to employ that after the hearing on June 8th, the court entered on June 10th. Since these dates, additional events have occurred and have been discovered that warrant reconsideration of the vacating order, including the appointment of new independent and non-conflicted counsel for the trustee. They literally want the court to yeet Richards out of the proceedings. Yeet. Your Honor, motion to yeeteth Ronald Richards. That's what they're asking for. They are saying that Richards has made false and inflammatory social media posts and public statements about Girardi, and this proceeding that violate the ethical rules to which he is bound and that unfairly target Girardi in an attempt to destroy her credibility before any claim is brought against her in this proceeding. Further, information contained in Richard's recent social media post reveals that he failed to disclose material connections to this proceeding in the parties in interest, as he was required to do. We went through his declaration in another video where we talked about the different um, disclosures, because they objected and said you didn't disclose this, and then the objection from the bankruptcy trustee was like, that shit's over and is irrelevant to this, the actual conflict. So they're saying there is new information showing that there's a conflict that they have issue with. Hint, it's the hustler and the housewife, but we'll get to that later down below. Given that even after the entry of that order, Richards has continued to harass EJ harassed Girardi through EJ's statements, including social media. This new evidence should be considered, and the order granting Richard's yeeting to act as special litigation should be vacated. No, it doesn't say that. I'm reading in the yeeting. Richard's thinly veiled attempt to shield himself from the consequences of his improper conduct by framing some of the comments as his opinion is irrelevant. Richard's public statements and speculations about this matter on Twitter are improper for any attorney, especially when appointed as special litigation counsel before the court. I think the appointed as carries a lot more weight than improper for any attorney, just saying. And violates the ethical rules, yet is taken as fact by his 1,600 plus followers. It would be so interesting to go back and look at the growth of the Twitters since he started talking about Girardi. It'd be very interesting to see. I mean, all of our accounts grow on different cases that our audiences are interested in. So that's not shade. It's actual just curiosity. Moreover, Girardi has the right to request a trial. I said that in any future adversary proceedings that Richards may attempt to bring against her. She does. He could bring motions to sue her. I've said this a lot. I think she will or could end up getting sued in this bankruptcy court for assets that they want to disengorge from her or claw back from her, saying that they were fraudulently transferred. That has a right to go to trial. And you can't make extrajudicial statements that could prejudice a party. So, accordingly, a significant likelihood exists that Richard's barrage, well, we'll see if it's a barrage, of social media postings and public statements will improperly prejudice any jury pool. That's one of the considerations under those rules of professional conduct that we previously talked about. Thus, Richards should not be permitted to serve as special litigation counsel. They had tried to ask the court for a gag order earlier, and the court was like, no. The court basically said, lawyers know how to follow the rules. And Erica's lawyers are saying, yeah, but no. Thus, Richards should not be permitted. He should be yeeted. Richard's behavior is even more troubling given his failure to comply with the Federal Rules 2014, which requires full disclosure of connections to debtors, creditors, and other interested parties. In particular, they're saying Richards failed to disclose that he had extensive involvement in the recently released documentary about Girardi, Keese, Girardi, and Girardi. Him and her Girardi, which featured multiple creditors in this case. While Mr. Richards has an obligation to disclose his connection to the court, he failed to include any reference to the documentary in his resulting connection to the parties in interest in the application. I'll be interested to see what the trustee says about this, because is it a connection to other interested parties if you're working behind the scenes on like an expose of a thing? I think a lot would say yes, and the court might say yes to that. It's interesting to know that that was happening behind the scenes. Reconsideration of this court's order permitting the appointment of Richards as special counsel to the trustee should be granted on the yeeting should be granted based on violations of the RPC and BPC. Newly discovered public statements, including on social media, which disparage Girardi and her integrity. I mean, and which are designed to prejudice any future jury pool against her. You guys will get to see them because they're going to bring them up. Failure to comply with the disclosure obligations. We'll see what the court thinks of that. It's going to break down to whether the court considers that expose to be an interested party. But I could see where a court could be like, I do not want to be a part of this mess. I could see it. Procedural history we've already covered because we covered the motion and the objection to the motion and the reply to the objection to the motion to have Richards appointed. So we're not going to get through the history of this. We know the history of this. We know the opposition. We know that the court overturned it. Newly discovered evidence. After the filing of this motion, Richard has amassed more than 1,600 followers on Twitter. Did they link his Twitter as a footnote? Yep. Twitter linked as a footnote, where his social media postings largely center on high-profile legal matters involving celebrities. Because of Richard's position as a member of the California State Bar and officer of the court, his followers look to him for legal analysis on current legal issues. Agreed. Richards appears to have a particular fascination with the legal issues related to women appearing on the various Real Housewives franchises, television shows broadcast on Bravo, as a majority of his Twitter feed relates to legal issues or allegations made against the women appearing on the television series. I don't follow his Twitter super closely. I see stuff on occasion. Do you guys agreed? Do you agreed? Do you agree? Do you agreed? Do you agree that that seems to be an accurate statement of the Twitter account? I know, I'm sure a lot of you follow his Twitter account because he is on shit fast. So let me know if you agree in the chat. I keep moving this. I'm sorry. I'm annoying myself. Certain copies of recent posts about Mr. Rory on his Twitter feed are attached as to Exhibit 1, the declaration of Evan Borges. Can we call him Evan Bougie? Can we call Erica's lawyer Evan Bougie? Sorry, Evan. It's not meant as disrespect. I think it's Borges. It just sounds like a bougie last name. We've renamed people worse, Evan. We have absolutely renamed people worse. I did not care for the run-ins on Twitter that you had. I'm assuming that this is Kimberly Archie. Kimberly Archie, it is good to see you. I love how you brought the stuff forward in the Hustler and the Housewife and brought the voicemails and the receipts. Much appreciated. Keep fighting. Following this court's ruling set forth by the order, Richards continued unabated in a we went with jihad. That's the word we picked. Slew, plethora, jihad is the word that we picked. Really? Okay. It's your motion. We've seen lawyers do stranger. We've seen people quote Fahrenheit 451. A little red star, it probably is pronounced Borges, but we rename everyone. We called poor Mr. Fuchs Fucks forever. Jihad is just, no. It's a no for me. Plethora. Slew. Onslaught. Onslaught would have been way better. Nope. Anyway, issues aside, I take issue, but issues aside, including social media posts and interviews on YouTube, told you, and podcasts, virtually always making reference to his new role as special counsel of the trustee. Well, yes. Very, very tough. Very fluffed about it. Yes, indeed, makes mention to that. For example, on June 16th, Richards tweeted Girardi's counsel filed a motion to withdraw and promoted his recent appearance on a YouTube show. Erica's legal counsel drops her due to lack of trust, featuring power attorney, and there's a link via YouTube. Just finished up great interview with Up and Adam. Hey, Up and Adam. Welcome to the lawsuit. No, look, don't mistake that. Adam's not in trouble. Adam's not being sued. Adam just is now a YouTuber who's commented on things whose YouTube video has ended up in a lawsuit. Look, it's linked. It's hyperlinked. Hey, Adam, we love your channel. With Up and Adam, who wanted to get the DL on yesterday's momentous, so this is quoting the tweet, who on yesterday's momentous procedural developments in hashtag Girardi fraud. After they brought up Girardi fraud in the last motion, I would have assumed that Richards would have stopped using the hashtag Girardi fraud. I just. See Exhibit 1. Goody. Mr. Richards appeared on the show on the same day to discuss the current events surrounding this proceeding, including the most recent motions filed by counsel. I mean, we all kind of covered it. A full recording of the show can be found. Hey, full recording of the show can be found. Hey, Up and Adam. We'll link it down below so that you guys can go see the show for themselves and talk about what you heard on Up and Adam's show and see what you think. We'll put a link here. I'll put a link in the chat. We can copy it and put a link in the thing. You go, Up and Adam. Shout out, Adam. Adam, the lawyers have watched your channel. A full recording of the show can be found on YouTube at there. Well, Richards attempted to state that his commentary would only be directed at the bankruptcy case involving Tom Girardi. It's kind of hard to separate the two, for real. The matter where Richards is not acting as special counsel, he purposely made it known that anything he said regarding the motions would apply equally to this proceeding. Ugh. They quoted him. They must have transcribed the interview. Did you know that YouTube transcribes them and you can actually see it? Hold on. You can actually see them. You can open the transcript on the side and see transcripts of the hearing on YouTube. Did you all know that? That was a new one for me. I learned that, but you can actually see it. So the lawyers can actually just go down and be like, "Doo, doo, 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 doo." Or they can just send it out to, and have it transcribed because lawyers. This is quote, let me preface with my comments are directed at the motion to withdraw filed in the individual Thomas Girardi bankruptcy. The lawyers filed the exact same fucking motion in both bankruptcies. I'm going to stay away from the Girardi Keys estate, the one I'm involved with, but let me let you in on a little secret. The motions are identical. Well, yeah, they're fucking identical. But for the record, I'm just going to comment on the case I'm not involved with. But the comments apply to both because they're the same. Thank you for the timestamps, lawyers. Timestamps are so helpful. Said from a former research attorney and a commentator here on the YouTubes. We love a good timestamp. Richard went on to comments on what he thought would be funny. They're not amused with respect to the motions filed. And also, Adam, what's interesting, I will tell you, is that ironically, they will tell you that the target of the investigation, Erica Girardi, didn't want my office to the trustee, but the target doesn't get to pick who investigates them. I mean, that's true. It's interesting that he calls her the target, but true. I think it would be funny if I filed an objection to the Thomas Girardi bankruptcy against her lawyer leaving and forced him to go to a hearing and delayed this a couple of weeks. That would be kind of ironic that he delayed my appointment and now I'm delaying his departure. I just thought I'd point out the funny irony for your fans. No. Because here's the thing. Shots fired. This is going to heat up faster than Brown and Salts, y'all. This really is. And none of them were giving interviews on YouTube. So you have to have a valid reason to object, not just because you think it's going to be funny. No, that's not, no. Ugh. Richards also admitted that he should limit what he says on social media given his different role now. Accurate. I would say that because of my position, I'm gonna not comment on stuff that is completely subjective, only because I have a different role now. There is a difference once you're on the case. Yeah, there's a big fucking difference once you're on the case. There is a big difference. There is a big difference. A big difference. I like that Up and Adam also got a footnote. But here's the thing, shade, like the page blocks his subscriber count. A full copy of the YouTube interview can be provided upon request. According to the Up and Adam channel, has 61,400 subs. Let's see where you're at now. Oh, those are super chats. Let's see where you're at. 62. Go, Adam, go. Adam's a friend of the channel. We enjoy his channel. I enjoy our conversations over on his channel. So yeah, you can all go watch the video. We linked it. And it's hyperlinked. So actually the court could just like go to YouTube and watch it. Also, Adam, don't be stressed. You didn't do anything wrong. You just had an interview. YouTube commentary ends up in lawsuits. It's just part of it. Welcome, friend. Notwithstanding an indirect violation of the limitations imposed by the ethical rule, Richards proceeded to state that he hoped Girardi would retain new counsel in this proceeding because he doesn't think her personality is consistent with compliance in a court setting. What does that even mean? He thinks she's difficult? I mean, he doesn't think she's going to comply? Her attorneys are saying she has complied in the other case. This statement constituted a blatant public attack on the integrity of a party and interest. I mean, I'm going to try to stop moving this page back and forth. I'm sorry. It's driving me nuts. Following the YouTube interview, Richards engaged in a number of other interviews and posted a series of tweets related to his wholly unsupported beliefs and accusations against Mr. Girardi and his counsel. For example, there's examples. On June 15th, one of Mr. Richards' followers questioned what would happen if Tom Girardi died in the middle of all this. I get asked that a lot. This is not how this is not how I generally choose to respond, but everybody has their own way of doing things. To which Richards replied, he is basically legally dead. See, that can be interpreted a lot of different ways. To answer the question, though, if Tom Girardi died, the bankruptcy would continue on because it's all already in the bankruptcy and the estates would continue to be parsed. It wouldn't change a lot within the bankruptcy because he's under a conservatorship and the conservator would continue to give information that they had to the bankruptcy court. But calling someone legally dead can be interpreted a lot of ways because Twitter's not for nuance. Ugh. On June 15th, when counsel filed a motion to withdraw from the case, Richard tweeted about the filing, and a Twitter follower asked what it meant. Richard responded that she, Erica, was facing evidence that shows she is more than just an innocent spouse. Oof. And is refusing to cooperate with her attorneys. This is an extraordinary step. I mean, oof. I can see why her attorneys have issue with that. And again, my oofing means this is ill-advised. Is the court going to find that this is outside the bounds? I don't know. For me, it's too close to the line for what I would be. I didn't talk about cases I was in at all. The media was like, "Do you have a comment?" No, I don't have a comment. I don't have a comment at all. This because this can be read as him saying she knows more than she's saying and she's refusing to cooperate with her attorneys. How would you know that? I mean, they said the relationship had been irreparably harmed, but we don't know how. Ugh, I don't like it. But again, what the court decides to do with this is beyond my opinion of no, I wouldn't. Look, these statements, if he were not a party in the case, I wouldn't have an issue with. But once you're a litigator in the case, it's just why walk that line? I don't know. Undeterred on June 17th, 2021, after sharing the breaking news with his fans that the motion to withdraw had been withdrawn, Richard sarcastically tweeted, "Well, at least we knew it was sarcastic. And if we knew it was sarcastic, then it's probably opinion." Apparently, the urgent and immediate breakdown of the attorney-client relationship has now been miraculously fixed. I love that they attached all of these. He then responded to a follower's tweet asking, "This must mean she had a way to pay them," by stating, "Probably." I mean, that's the speculation. It's just outside of the bounds, maybe, for him to speculate on, because this is actually talking about the attorney-client relationship of the opposing counsel and literally the opposing party or target party if he files suit against her. So that's tough. And I can see why they're frustrated by it. We'll see what the bankruptcy trustee says in their objection, because it might be this is all First Amendment. He's exercising his right, but he's now involved. If not involved, I wouldn't have as much issue with this. Like, these things said before are like snarky, like, "Oh wow, everything's fixed now. That was fast." but he's directly commenting on the attorney-client relationship and indicating that she's not paying counsel, or that that's what the breakdown of the relationship was, which it very well could have been, but we don't know, and it's not for us to know. That's attorney-client privilege. When a reporter who follows Richards on Twitter asked whether the motion had been filed because the client and counsel had reached an agreement, obviously they reached an agreement. The motion to withdraw said they reached an agreement. Richards said definitively, without support, no, they got paid. No, they got paid in, so it's all good now. That's the quickest way to repair a relationship, is a large retainer. Oof. As opposed to saying, it seems it's been repaired, it's possible that. That's not speculative. Do y'all think that's a statement, or do y'all think that's an opinion? How do you read that tweet? Twitter's not for nuance, people. It's hard. It sounds like a statement of fact. To me, it sounds like a statement of fact. There's not enough lip gloss in the world this evening. Similarly, on June 18th, Richards tweeted information about the listing price of the Girardi residence, to which a follower replied, my opinion, it was overvalued to borrow the maximum in order to stiff lenders. A fair opinion for a commenter on Twitter to have. But as the attorney, let that shit go. Let it go. Let it go. Let that go. But no, Richards responded by stating again, without any support, now you guys are pretty smart. Followers, let me tell you, you are dead on with that assessment, in my opinion. In my opinion, does not protect you from all of the shit that you say. Let it go. In addition to making false and inflammatory statements about Miss Girardi directly, Richards has publicly expressed support of others who have constantly attacked Girardi on social media. I don't know if that's gonna fly. Liking a shady tweet is gonna be a lot harder to prove than direct statements. For the court to say conclusively this is like liking a shady tweet, though you can get in trouble. Not to say you can't get in trouble for that. It's just harder. They're putting it all in here. Of course they're putting it all in here. Why would they not? For example, on June 28th, I don't know who Scott Hansen is, but he got pulled right out. Scott Hansen, who has been a prolific and serial vilifier of Girardi. I hadn't even gotten to that yet. I don't know who Scott Hansen is. But okay, a prolific and serial vilifier of Miss Girardi with tweets like, Erica, you thieving. Oh, you thieving sow. Oh, he's calling her like a thieving cow. Sorry, I was so confused. Erica needs to pay for her crimes. And Erica needs to pay for her crimes, wrote that it will be understood by your Mr. Richards followers if you're unable to keep us informed on the Girardi case if Erica is able to get her gag order, to which Richards responded, don't worry, Scott. We will be covering it all. Is he talking about himself in the third person? I do that too. So that's not shady because I do it. I'm like, oh, we're covering this tonight. It's just me. Well, no, it's me and Fred. We're doing it. Doing it. No, that's weird. That's weird. That's the first song that came in my mind with doing it, but no, we don't need to get that clipped out of context. I lost my spot. Okay. Mr. Richards responded, don't worry, Scott, we will be covering it all. And I was appointed today. So let's just keep moving forward and working collaboratively to get to the right result. My okay, they're not gonna no. Matt Bond, I don't know what boop the floof means. I don't know what you mean by boop being the floof. I'm sorry. I don't know. See, the working collaboratively part is it's messy. Whether the court finds that particular thing to be a problem, it makes it messier when you are not asking a question or seeking more information. That is shouting out someone who's a hater. People are allowed to be haters. Um, but you don't need to throw gasoline on that shit as appointed counsel, in my opinion, because it's going to make it messy, and it clearly just pissed off Erica's attorneys. I don't think Ron Richards cares that he's pissed off Erica's attorneys. I think this is probably this. I don't think Ron Richards is unaware of what the rules are, and I think that these are intentional tweets. I don't think this is like an accidental tweet. I don't think this is a like whoopsie. I think this is known. And it's clear that he's gotten under the skin of Erica's attorneys, and they're like, this shit's improper. Richards also recently made statements on social media regarding his involvement in a documentary about Girardi Keese. I did not know that. Girardi, Girardi released on June 12th, 2021. Specifically on June 3rd, Richards tweeted, even though he participated in the production because of his possible appointment, he was cut from the show. Do you think he was bummed? I think he was probably bummed. But if you stay appointed as counsel, remember his fees will be 35 to 45% of whatever he recovers from Erica, which is assumed to be 20 million. And we're gonna squeeze the floof. Okay, the floof does not want to be booped. He does not want to be floofed. So he was just like, whatever. He wants to wander around the desk. So I think that being cut from the documentary is probably a good thing if you're going to be appointed, because the appointment stands to make you a hell of a lot more money than the potential documentary will, which is probably not something that's going to gain anything other than exposure, because I imagine it's probably not paid. But even if paid, probably not as much as whatever 45%, potentially 45% and costs of $20 million is. So, all right. What else? Yes, I was involved with background. Hold on. Additionally, when a follower asked if he had seen information about the documentary, Richards replied, yes, I was involved with background. Indeed, Richards could not help but boast his extensive involvement in the production, complaining to a follower that it was unfair that he was cut from the show because his 16 hours of footage with expert analysis could not be replaced. I mean, they had other lawyers on the show. It's attached, maybe. Notably, Richards has since deleted this post from his Twitter feed. Oh, I'm sure they screenshotted it. Furthermore, Richards has undermined the integrity of this proceeding by publicly commenting on and questioning the veracity of creditors' claims. Kimberly Archie, hi, Kimberly Archie, is one of the petitioning creditors in both this proceeding and the bankruptcy of Girardi. As a person, Richards has been engaging in a vicious exchange with Archie on social media, basically accusing her of making a false claim. Ugh. The things I have not seen go down on Twitter. For example, on June 9th, Richards wrote, why would you file that claim? You have no standing. Why wouldn't the law firm file it themselves? See Exhibit 1 at paragraph 29. I don't know what that's in response to, but in response, Miss Archie's tweets regarding the contract supporting her claim, Richards continued the attack. Had you posted the contract with your claim, we would know, but you didn't provide any backup. But you can't litigate a claimant's claim on Twitter. That's for the bankruptcy trustee to ask about. The bankruptcy trustee is the only one. He's only brought in with regard to Erica and getting money back. If Erica got money from the estate improperly, from the law firm estate improperly, his job is to go find that alleged $20 million and bring it back into the bankruptcy to go to the valid creditors, not to ask the creditors to prove it. That is what the bankruptcy trustee is for. The bankruptcy trustee and the court evaluate the claims of the creditors, not Twitter. Oh. And what's going on in the proceedings is not really for him to comment on as an arm of the bankruptcy trustee. The bankruptcy trustee couldn't make that comment. Twitter continued. Richards continued on Twitter alleging, it is missing essential documents, but you know that. Why would you say that on Twitter? The bankruptcy trustee can deal with it and make an objection to it if they need to make an objection to it or not. Coming out, literally leave the creditors alone. Like his job is supposed to be going after money that Erica may have to give it to the creditors. The point of the entire bankruptcy, the point of the bankruptcy is to get the people who lost their money back their fucking money. That is the whole point. The bankruptcy trustee is hire somebody to do that. The point of getting Erica's money back is to give it to those creditors. Attacking them on Twitter doesn't make any sense to me, especially when you're getting 35 to 45% of $20 million potentially. There's a lot of financial incentive there. I don't understand attacking creditors. If there's an objection, they get made inside the court. I don't like that. I don't know the whole context. I do not like the way that it is spelled out here. Which, in reference to Archie's appearance in the documentary, Richard commented, Kimberly, to call yourself a victim is an abuse of the word. The woman's son died. Ugh. Okay. Let's not tell people how they feel on Twitter. There has to be a history there on Twitter that I am unaware of. It just seems unnecessary. Okay. The motion for reconsideration should be granted. We have been, oh my God, it's 2 hours and 20 minutes. Mods, I'm so sorry. I hope you took that bathroom break. We're gonna keep going till the end of this motion. We're not gonna get into the legal standing and precedent. We will talk about that another time. But it's going to go back through the rules of professional conduct that were spelled out in the previous motion, because these are new tweets. These are new tweets, but the same allegations that they made before as to why he shouldn't be the special counsel. So it's the same law and why it should be analyzed, and they're breaking that law down. They're talking about when new evidence has become available, it's proper to rehear this motion. Reconsidering the court's order is warranted based on newly discovered evidence. That's because it's from the date of the last thing to the new thing. And that's when Richard's recent behavior violates California ethics, and they attached it. California Business and Professions Code sets forth the duties of a California attorney, including to maintain the respect due to the courts of justice and judicial officers, to advance no fact prejudicial to the honor or reputation of a party or witness. And that could, let me know what you think about the statements and whether that fits. Not to encourage either the commencement or continuance of an action or proceeding from any corrupt motive of passion or interest. Interesting, they included that in there. We know how they feel. We know what they feel. Did they actually try to legally call Ron Richards a clout chaser? Is that the lawyer response? Is that the legal clout chasing? I feel like that section is what that is. Not to encourage either the commencement or continuance of an action or proceeding from any corrupt motive or passion of interest. I feel like that's what that is. Please stop knocking my Kleenex onto the floor. Thanks. I need it. More importantly, Rule 3.6 of the RPC restricts an attorney's ability to comment publicly about an ongoing litigation. And this is what changed when Richard became special litigation counsel. A lawyer who is participating or has participated in, and this is key when I talked about everything that came before he was appointed, in the investigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know, one, will be disseminated by means of public communication. I mean, ding, 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 Twitter. Two, have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. So that is prejudicing a party. can absolutely come into that. They are saying that the statements, including tweets, directly violate both F and G. I am clearly not paying attention well enough. Hi. We're just going, yeah. Mods, you don't need to worry. When I go over time, Fred is on your side. He's like, Mom, you're done. Wrap it up. We're almost done with this motion, Fred. Thank you for your participation and cooperation. And he just jumped right off my hand. Richards has publicly and falsely commented on the case and is publicly advancing and insinuating facts disrespectful to counsel. I mean, he directly commented on their relationship and prejudicial to Girardi. Interesting what you guys think, if it's prejudicial to Girardi and what the court thinks. Do you think the statements, look, no matter how much you agree with the statement, no matter how much you dislike Erica Girardi, could the weight of a lawyer involved in the case saying those things be like, yeah, well, now I believe that she knew? Could it sway you? And that's what they're arguing. No, what you're not going to do. Thanks, buddy. His public comments also show that he solicited his position as special counsel and is commencing and continuing his vendetta against Girardi through some strange obsession with her and this case. Oh, they said it. They said it twice. Richards has gone so far as to substantiate comments made by the general public. Let it go. Let it go. Like, people are going to say what they're going to say under your Twitter, but saying ding 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 is problematic, which have no basis in fact or support in any evidence or pleadings presented to the court. Again, no claims have been brought by Richards against Girardi in this litigation, yet Girardi has continued to make repeated comments on Twitter that are false, inflammatory, and constitute harassment, they think. Indeed, in his June 16th interview, is this back to the Up and Adam interview? Richards appears to acknowledge his ethical obligations due to his different role. Oh, they commented on that earlier. This is the link. Yep, same link. 2 shout outs, Up and Adam. Richards almost mockingly states that he must stay away from commenting on this proceedings as he is ethically required to do, but then proceeds to advise listeners that everything he says is regarding the Girardi bankruptcy applies to this case. His statements display a lack of respect for the court and judicial officers, repeatedly advancing prejudicial and false statements designed to impugn Girardi's reputation and appear to be motivated by his focus on promoting himself on social media. Three times they've said it. His social media posts go far beyond permitted statements by a lawyer regarding basic facts about the matter, which is what I thought we were going to get to. Just like this happened, this was filed, new court date. This is not just basic facts. This, for me, goes beyond basic facts. Whether the court finds that it goes so far beyond basic facts that they remove him, we will see. And instead, they say it rises to the level of weighing in on details of documents filed and appearing to put his stamp of approval on, they say, blatantly false statements and alleged allegations taken by Girardi and her counsel, or alleged actions, sorry. Richards appears intent on litigating his theory of the case, a case that's not even been filed, against Girardi in the public eye. Moreover, because she has a right to a jury trial in any future adversary proceeding brought by trustee, Richards' public statements are a blatant attempt to prejudice any jury pool against her. I wonder if they would argue that the documentary is that as well. Indeed, all of Richards' statements are designed to bias the public against Girardi. And again, the public, 2 things can be true, by the way. It can be true that you think that Erica knew and that she sucks. You're allowed to have that opinion based on what you've seen, what you've heard. You're allowed that opinion. But an attorney involved in the case can't co-sign that opinion. Even if it's their opinion, you shouldn't know that that's their opinion, right? So her lawyers are protecting her right to have an unbiased trial if a trial goes forward. That is their duty and obligation. And 2 things can be true. She can suck, and she can also have the right to a fair trial, but an attorney can't violate their ethical duties to not prejudice a jury pool and not make extrajudicial statements. Two things can be true at once. You can agree with his statements and he still should not have made them. Those two things can be true. Indeed, all of Mr. Richards' statements are designed to bias the public against Girardi. And this is a case where you can't put the shit back in the horse, right? Because Girardi has the right to a jury trial in future adversary proceedings, but by the trustee, his public statements are a blatant attempt to prejudice. We've said that. That's been said. Like, it's been said. While Richards has a First Amendment right to comment on Twitter, the California RPC restricts the right to a pending investigation or legal proceeding, and he is now involved in a pending investigation. He's involved in an investigation and pending legal proceedings. Nor does Richards have a First Amendment right to be special counsel to a Chapter 7 trustee. Yes, we know. In this case, Richards' public comments after being appointed demonstrate that he has violated the rule. He failed to comply with the required disclosure, which is going to get into the involvement in the documentary. I will be curious to see what the court rules on that, because I'm curious to see what they rule, because it's not like a direct party, but it's like it's an interest with the documentary. I think that's going to be very, very interesting. In this case, Richard's disclosure in the application of his alleged disinterestedness says the firm is a small firm, reviews all matters, but doesn't say anything about it. Absent from the application is any disclosure by Richards of his significant connection, including 16 hours of taped interviews to the documentary released on June 12th, which also featured petitioning creditor Kimberly Archie, rather than disclose these material connections to this proceedings and the party of interest, because Kimberly Archie is a creditor and a connection to the creditor, whether I'm sure they didn't interact during filming, but they were connected with the same thing. But then he was removed from that. I don't know how the court will find that. Richards waited until after his employment was approved, and then on June 18th tweeted about his involvement with the documentary, including his involvement in the production and 16 hours of taped interviews, which he lamented, they say, were cut due to his possible appointment. Conclusion, yeet. Declaration, I'm a partner. I've looked at Twitter. Hey, up and at 'em. 3 times the charm. Another hyperlink. Exhibit 1, Twitter. 2 hours and 30 minutes. We're going to move fast for court of public opinion, I promise. This is a lot. So Twitter. This goes through all the things that they're saying he said. This is these are the receipts. The receipts are attached. We love emotion with receipts. Erica Jane's legal woes chronicled in The Housewife and the Hustler. This was an extensive documentary. Investigative piece. Either way, I'm sure the public will benefit from the collaboration of so many professionals and alleged victims. I mean, when it comes to the Rui Gomez family, they've had to sue their attorneys like 17 fucking thousand times. That's hyperbole to get to the point where they attached all of his assets. I don't think we need to say alleged victims. I mean, there's nothing alleged there. My thoughts. Barbara says, hi, Barbs. I hope it comes to another platform because I don't have Hulu and can't afford to get it. Hi, Barbara. Even though I participated in the production, how is that responding to what she said? How is that responding to Barbara? It's just, what? Hey, Barbara, even though I participated in the production because of my possible appointment, I was cut from the show, so I probably won't be watching it either on Hulu, so don't worry. Really? Okay. That just seems to be whatever. This is the one from whoever Scott is, Ron Richards. Mr. Richards, it will be understood by your followers if you are unable to keep us informed. Don't worry, Scott. We will be covering it all, as I was appointed today. So let's just keep moving forward and working collaboratively to get the right result. The right result, again, should be getting as much money back to the creditors as you can. Ron Richards, does Erica Jane understand when this is hard to read. When files bankrupt, it's the public's business and it doesn't matter that she's on a reality show. Who the hell does Erica think she is? Amanda, don't worry, I was appointed. Interesting. I don't even think that one came up. Oh, Lady Justice, blindfold. Um, Jordy Keys' bankruptcy trustee got the go ahead to hire Ron Richards, who has criticized the law firm's founder's estranged wife to investigate whether she has assets belonging to the defunct practice. Full story from Law 360. Um, might as well throw in the towel, Erica. Ron Richards will not stop until justice has been served. Oh, hey, Kim Archie. How will this help the victims? And we didn't pick him, hire him. The trustee did. Ron Richards said anyone is free to hire their counsel of choice and pursue any non debtor. Retaining a competent and effective attorney generally helps all creditors in any bankruptcy estate, so improperly diverted assets can be returned to the estate. Well, yeah, diverted assets are exactly what should be returned to the estate. Oh, there's the Twitter exchange. No shit, that's why victims have hired competent attorneys. We didn't hire you. Don't make it seem like you're for the victims now after you treated me and Kathy Rue Gomez on Twitter, released a voicemail of a victim against their wishes. Save it, Ron. He did in fact do that. I was not pleased with that. I had a moment about that on Twitter. I called it disgusting on Twitter. So when people are like, Ron threw some shade at you in an interview, I'm like, I mean, I get it, because I did say it was disgusting on Twitter because I thought it was. You don't release people's things against their wishes. Oh, here's the whole thing. Kimberly, you call yourself a victim is an abuse to the word. You receive fees from client settlements diverted from Girardi. You're a creditor who didn't get their fees paid, but you never identified what entitled you to the money in the first place. Your settlement was never stolen. Sounds like you have no clue what you're talking about. The money for the claim is for legal fees to a law firm related to my son's death, not for fees owed to me. Interesting how you speak to those you claim to be going after Erica for. You're a clown. You filed your claim for you, not a straw claimant. Stop thinking this should not be litigated on Twitter. But Kimberly said, I filed a claim for the money Tom owes in legal fees to a law firm in Massachusetts related to my son's death. A lot of law firms did not get paid. And we saw that uh, in a lot of the claims where associated counsel came in on cases and did not get paid. And then arguing back and forth over that, which we're not going to dive into. It's just. There's a lot here. Yeah, that's a lot of tweeting. I'm not going to read the whole tweets because we've been going on for 2 hours and 34 minutes. Yeah. It keeps going. Axe, by the way, the law firm is Boris Trezon's firm that's also involved in both of these. Oh, okay. That's a lot of a Twitter exchange. We will. That's a lot of a Twitter exchange. This is the Up and Adam video. Erica Girardi's attorney moves to withdraw from representation. Could this be a strategic plan? This is he's basically legally dead. So these are just all the receipts for what they've already said, which we know. This is the breaking news. This is the co-signing of the earlier statement. They're alleging that more tweets about the Housewife and the Hustler. What did you think of Housewife and the Hustler? Can we get a thumbs up or down? Since I was cut out of it due to my appointment at the last second, it was unfair, as 16 hours of footage with expert analysis could not be replaced. Hopefully the next doc, it will be fixed. It did reveal some practices that were horrific and glad they were exposed. I thought he didn't watch it. There's a very insightful article with pleadings attached to it with some of the new reveals. Would love feedback. Can we get a thumbs up or thumbs down? The Girardi Mansion price big lowered. All the receipts. So all the Twitter receipts, all the Twitter. So it'll be interesting to see what you guys think. I know we've been live for like 2.5 hours. It's a lot. There's a lot of Twitter here. We've gone through other litigations where there's a lot of Twitter. I know. I know. There's a lot of Twitter. I we're gonna keep going, but we know there's a lot of Twitter. But Twitter before and Twitter after are different Twitters. And then the proof of service. Okay, we're at the end. All right, Jesus fucking God. We're at the end. We're at the end. We're at the end. Yo, that was a lot. Tuesday, we're going to go over some more questions. This is a whole lot. It'll be interesting. I'm sure the bankruptcy trustee is going to object. Well, maybe they won't. I'm not sure about anything. Maybe they will, maybe they won't. We'll see. We'll see what the lawyers decide to do for the bankruptcy court. I thought that after the appointment, you would see a different type of tweet. We haven't seen a different type of tweet. Erica's attorneys take issue with it. There are things that are for Twitter and things that are not for Twitter. And there, everybody has their own decisions to make on how they take it. And we'll see what the court thinks of it, because at the end of the day, the court's going to have to set a date for this motion. We'll be filing it to see what the court thinks. I won't be surprised if they remove Ron Richards. But if they don't, I'd like to see the court's reasoning, because there are some comments with regard directly, particularly to opposing counsel and opposing counsel's relationship with their client. It's going to be very, very, very interesting. So I know this is why I stopped and got to some of the Brittany questions in the middle, because there was so much here. Do the YouTube things. We're going to do a real quick court of public opinion question. There are over 3,000 of you that have hung with me for over 2.5 hours. Y'all, it's just, this one is a lot. That was over 67 pages. A lot of it was a Twitter printout, but Erica's attorneys had a lot to say. And again, two things can be true. We all have a lot of questions of what we have seen from Erica, what we don't like from Erica. If she has any money from the law firm, it needs to go back into the bankruptcy. But she also is entitled to process, and she's also entitled to proper process. You know why? Because what you don't want is the money to get appealed. You don't want creditors to be fucking with this for a million years. You want this to get dealt with, and you want it to get dealt with properly. So just deal with it so it doesn't become a mess on appeal that she was prejudiced prior to trial. If she goes to trial and they get judgments for lots of money, you want it to stick, and you want it to come out from her to the creditors. You don't want an appeals court going, yeah, that shit was improper down the road. Protect the money that you're going to get. Protect it. Protect it. Protect the money. That's the most important part. All right, mods. Thank you for being here. I'm going to try to get to some of the back super chats, and then we're going to get to it. I will answer more questions on Tuesday. I will not cover much more on Tuesday. I'm sorry it went so long. Thank you for hanging with me. It was I always am like, is it enough topics? Is it enough topics? Too many topics, but so much happened. I wanted to talk about it. Casey said, insurance law paralegal, what are your thoughts regarding malpractice insurance, especially in light of the Alzheimer's diagnosis? Hi. You want to attack my earrings? Sweet. I don't know how much malpractice he had. I think there are big questions if the Alzheimer's was going on and what was known before. I've raised my concerns before. I worry that clients were not properly advised if there was mental decline there 6 months ago, 8 months ago, a year ago. I don't know if it goes back further than that. I can't imagine it could have gone on for that long, but you never know. Someone who clearly worked with Girardi spoke in The Hustler and The Housewife and said, I didn't see any decline. So then one has to worry about whether all the information in that is accurate. So I have a lot of questions. Let's just put it there. I have a lot of questions, but I don't know what his malpractice insurance was, how much he had, or where that is in all of this. Fred is definitely a good meowderator. He is done with me being live. Can you tell? Amber, Amber is a former client of Tom Girardi and said Tom didn't carry malpractice insurance. I know I had read that. I didn't think that he did. In California, you can do that. The clients have to sign a waiver. Unfortunately, clients often don't know what that means because in this case, the state bar didn't let them know there was anything to be worried about. Okay, a few back super chats. Thank you all for your super chats. I appreciate it. Allie, the mama bear, said my dog Gus Gus, oh Gus Gus, like Cinderella, and Poe, Star Wars, are happy to figure out your shows. Keeps the husband out of the bed. More room for us. LOL. Have a great night. Mike Megan 919 said it seemed that Erica thought Tom was going down, not her. I think she's shocked. Thank you. The mods are awesome. Separate property is separate property. The thing is, while she was married, it was all combined. So some stuff can be sold off.